Hello again, and welcome to week one. In this module, I'm going to talk about the sources of law, the structure of the judicial system, and provide an overview of the First Amendment. There's a PowerPoint that should aid you with your reading, which is chapter 1 and 2, and you have a discussion that you need to complete. So let's first talk about sources of law. Our American legal system is built on a foundation of case law. That is, written opinions that explain the court's rulings on legal issues and disputes. These judicial opinions highlight three characteristics of American law that you should know about. First, that the law is constantly changing. In fact, about 15,000 new federal, state, and local statutes are enacted each year, and more than 50,000 judicial opinions are published annually. The second characteristic is that there is a constant interplay between the desire for flexibility and progress and the need to maintain stability and certainty. After all, a social order depends on stability and law that is capable of changing with a dynamic society. The expectations of equality and justice have changed over time, and so must our laws. And third, American law is derived from a multitude of sources. Let's talk about those sources. There are 6 of them. First, common law, which is the accumulation of legal principles based on thousands of decisions that have been handed down by English and American courts over the last 10 centuries. Second, the law of equity, the discretionary law in the form of judicial decree rather than monetary damages. Third, statutory law. These are laws created by legislative bodies, acts of Congress, state legislators, and ordinances adopted by city and county governments. Fourth, constitutional law, the most important, or at least most influential source of law in the legal system. And if you ever get the chance to see the Constitution, I highly recommend it. It's also kind of my favorite law. Administrative law is fifth, which is any law that's made by a legislative body like the FCC, which is the Federal Communications Commission, the Federal Trade Commission, which is FTC, or the Federal Aviation Administration, or FAA. And then sixth, international law, formal and informal treaties, agreements, and conventions. Think about things like the United Nations or the North American Free Trade Agreement. That's where you'll see international law really come into play. Now let's take a look at the structure of our judicial system. One way to distinguish between courts is to determine the jurisdiction, that is, the subject matter that the courts rule on, or the geographic area that the courts rule within. Let's start with the federal courts. One type of federal courts is the Article III courts. These courts include the U.S. District Courts, the U.S. Circuit Court of Appeal, and the U.S. Supreme Court. Next, we have state courts. No two state court systems are exactly alike. It's just the way our country is built. Most states are made up of trial courts, appellate courts, and the highest court in the state. Because each state has its own constitution, however, the way that they're set up does vary. Our third item for discussion in this module is the First Amendment, derived, of course, from constitutional law. Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably assemble and petition the government for a redress of grievances. That's good stuff. We, the people, in order to form a more perfect union, established, well, a lot. Those 15,000 new statutes are enacted every year are trying to establish a more perfect union. Those 45 words constitute the First Amendment to the U.S. Constitution and provide, among other things, rights that citizens may speak and write freely without the fear of censorship from the federal government. In his dissenting opinion in Ginsburg versus the United States in 1966, Supreme Court Justice Potter Stewart wrote, "Censorship reflects a society's lack of confidence in itself. It is a hallmark of an authoritarian regime." Think about that. Think about what's happening right now in our society. How is that reflecting upon us? Supreme Court rulings, however, make it clear that the First Amendment is not absolute. There are a number of competing societal interests that limit the unbridled exercise of the First Amendment. Some of these competing societal interests are the right to one's good name and reputation, the right to be left alone, the right to a fair trial for a criminal defendant, the right not to have obscene material forced on them, the right to profit from one's intellectual or artistic creations, and the right to not be cheated by false or deceptive advertising. One way the courts have approached this challenge is through what is called the balancing effect. For example, the societal interest of protecting property rights of authors through copyright laws limits freedom of speech and freedom of press automatically. The courts attempt to balance these rights through new laws, regulations, and statutes. And that's what a judicial system is all about. Balance. So this brings us to the end of this week's video lecture. Remember to read the rest of the materials and participate in this week's discussion. I will see y'all next time. Signing off.